ang natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
You have to be guided by Section 1 of Rule 138 because Rule 138 is one of the sources of legal ethics. Who may practice law? Ang sinasabi dyan ay any person heretofore duly admitted as a member of the bar or hereafter admitted as such in accordance with the provisions of this rule and who is in good and regular standing is entitled to practice law. Iyan po iyon. That is ULEP versus Legal Aid Clinic. ULEP versus Legal Aid Clinic. Okay? Yan yung doktrina. Alin yun, sir? Yung any person. Kasi any person may mean na pwede palang mag-practice. Kung hindi yan natin makokorek, pwede palang mag-practice ang juridical person. So let us disabuse.
The shares of XYZ, the 40% shares of XYZ, likewise owned by the same foreign corporation owned by foreigners that directly owns 40% of ABC Corporation. So to repeat, let's say the foreigners, right? The foreign held corporation owns 40,000 of 100,000. At the same time, the foreign held corporation owns 40% of XYZ share in ABC Corporation. So the question now is, based on these figures, is ABC a Philippine national? Is it qualified to invest in public utility? Is it compliant with the Constitution?
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
in relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay, but in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
To our dear attendees from different parts of the country, I pray that you're all in great state of health. This free webinar is streaming live via the VLC Law Center's YouTube channel and Facebook page. If you can hear my voice clearly, please type in the comment section #VLC. Thank you. Yes, thank you. Optimize this learning opportunity. Share this free online lecture to your friends and together learn at the comfort of your homes. I want to formally welcome you all to this free webinar. This is part of a series of free online lectures brought to you by the Virtual Law Companion of VLC's Law Center. Allow me to share to you this good news. The Virtual Law Companion is the newest innovation of VLC's Law Center, which aims to provide an easy, convenient, and quality bar review experience. The Virtual Law Companion is a web application that is hosted on a dedicated cloud server. It can be accessed via the internet 24/7 for any web browser using any device or handheld computers like Android or iOS phones. Meaning, you can study anytime, anywhere, and from any mobile device. Please visit our website at www.vlcslawcenter.com to know more about our programs and activities. Before we formally start, please take note of some reminders. First, this free webinar is pre-recorded to ensure the uninterrupted streaming of lectures. Secondly, VLC team will be with you to assist you should you need more information about our program. Please visit and subscribe to our YouTube channel and Facebook page. Without further ado, please give your virtual claps and welcome our lecturer today. Again, this free webinar is brought to you by our Virtual Law Companion. Maraming salamat po. Together, we can make things happen. Together, we can.
Magandang araw sa inyong lahat. Ako si Attorney Edward Chico. Ang topic ko for today is the family code. So what I'm gonna be doing is discuss the family code in a nutshell. So meaning in few words, maiintindihan nyo na kung ano yung mga konsepto na medyo hindi malinaw sa atin. I realized that for the most part, every time we review the law, we tend to memorize terms, we tend to memorize details, yung mga grounds, yung mga enumerations. Of course, there's nothing wrong with that. Kaya lang ang problema, if there is too much focus on that, we fail to understand, we fail to capture what exactly is really important in learning, which is basically understanding. So dito sa ating lecture series na ito, at least for purposes of my lecture, I would try to present to you the family code in a nutshell, explaining each and every concept, the relationship of all the provisions. So magsisynthesize tayo at syempre sasagutin natin yung tanong na bakit. Na-realize ko sa lahat ng katanungan, pag nasagot mo na yung bakit, minsan nga hindi na importante kung saan, hindi na importante kung kailan, minsan hindi na rin importante kung sino. So yun ang i-attempt natin ngayon. Yan ang gagawin natin. At medyo excited ako sa topic ko kasi lahat naman tayo nagmamahal. Ako nagmamahal. So which is why this topic is very, very close to my heart. When it comes to marriage, lahat tayo talagang ika nga one way or another excited about it. Naalala nyo, meron nga nung balita about 2 months ago, di ba may lalaki nagpakasal siya sa rice cooker? Pero syempre nakipaghiwalay daw siya after 1 week. Alam niyo kung bakit? Kasi hindi naman daw marunong magsaing, hindi ba? Meron pa ako nabasa, kinasal siya sa sarili niya, kaya lang nakipaghiwalay siya kasi nga masama ugali. But of course, these are just weird circumstances. But at the end of the day, we get married. So it's pretty important for us to discuss that. So mag-start na tayo ha. Una, let's talk about the nature of marriage. Sabi ng Supreme Court, a marriage contract is at the very least a civil contract, but not at most a civil contract. And it's it's quite intriguing why. Hindi ba? Alam nyo kung bakit? Because marriage, if you look at that Article 1 of the Family Code, is the only contract that is not actually subject to stipulation. So it is the family code that governs all the terms and conditions of marriage. And even if you are allowed to actually fix the property relations, you have to understand that you're still subject to the limits imposed by law or the family code. So ang tanong, bakit ganyan ang marriage? Diba? Ito lang yung kontrata where both parties cannot actually sit down and discuss the terms and conditions. And even, as I said, even if they discuss property relations, may mga limits pa rin. For example, hindi ba, pag nagkaroon sila ng prenup, they cannot provide in the prenup that during the first 10 years of the marriage, they will be governed by the absolute community. And then by the 10th year, they will be governed by the, by the conjugal partnership. So bakit hindi pa pwede yun? Akala ko ba they can fix their property relations? Of course they do. They can. But the thing is, the family code specifically provides that the marriage, that the property relation should exist at the precise moment the marriage is celebrated. So isipin mo, pagdating sa property relations, kinakailangan, subject ka pa rin sa limits ng batas. And the important question there is bakit? Ano ba yung nature ng marriage? And eto na yan. Ito yung gusto kong maintindihan ninyo. Okay? Principle number 1, marriage is vested with public interest. Marriage is vested with public interest. And that explains why, if you talk about marriage, it cannot be subject to stipulation. Kasi may interest ang Estado sa pag-aasawa. And the state would want to see to it that all the terms and conditions of marriage are those provided for by law. And the next question is why? Bakit? Kasi nga, sabi sa Article 1, marriage is the foundation of the family, which makes it, of course, an inviolable social institution. And take note of the operative word used, ano? It is a permanent union between a man and a woman. Permanent. So, ang pagkakaalam ng batas, pag nag-asawa ka, permanente dapat. Again, why? Because marriage is impressed with public interest. And if you look at all the provisions of the family code, everything will always have to go back to that principle. Again, yung principle natin, principle number 1 natin, marriage is vested with public interest. That explains why if you file a petition for nullity or annulment, the fiscal intervenes to see to it that number 1, the pieces of evidence are not actually fabricated. And number 2, there is no collusion between the parties. Isipin mo, nakikialam yung fiscal. Why? Because he represents the state. Alam niyo ba, pag nag-file ka ng annulment or nullity, it is the only civil case. I mean, meron pang iba, but amongst the few civil cases where the fiscal actually participates or takes part in the proceedings. As in sa trial, kasali siya. Nagko-cross-examine siya. And more importantly, even before it goes to trial, he has to even issue a certification certifying that there is no collusion and that there is no fabrication. Bakit? Kasi nga, yung Estado ay may pakialam sa pag-aasawa. Again, because marriage is vested with public interest. So ano pang mga repercussion yan? It also explains why if you file a petition for legal separation, for example, there's a 6-month cooling off period. Kasi ang inaasahan ng batas, guys, kung sakaling ayaw nyo na, pag-isipan ninyo. Baka naman after 6 months, pwede pa kayong magsama. So if you basically look at those two provisions, it leads to one conclusion. Since marriage is vested with public interest, since it is the very foundation of the family, which incidentally is the basic unit of society, ayaw ng batas na naghihiwalay ang mag-asawa. At kung maghihiwalay kayo, the ground for either nullity or annulment should be exclusive. At kung maghihiwalay kayo and if you would initiate some proceeding, the state has to participate through the fiscal. And in fact, even the Office of the Solicitor General is included. And the Office of the Solicitor General, assuming of course it does not agree with the decision of the trial court, can even file an appeal in behalf of the state. So, ang Estado ay may interest sa pag-aasawa, ayaw kayong maghiwalay. And that also explains why same-sex marriage is not recognized in our jurisdiction. And ultimately, it explains why in our jurisdiction, there is no divorce. Kasi nga ayaw natin na naghihiwalay ang pamilya. And since marriage is vested with public interest, if you talk about children, you will realize that the family code actually gives so much perks and advantages to legitimate children as opposed to those accorded to illegitimate ones. Bakit? Kasi pag legitimate children, it is basically in keeping with raising a family, which is very, very crucial in our society. Kaya yung binibigay sa illegitimate children, mas kaunti. Why? Because the law wants to discourage people from having illegitimate children, because having illegitimate children essentially is anathema to building a family, which is the foundation of our society. Kaya pansinin mo, an illegitimate child, when it comes to succession, only gets 1/2 of what the legitimate child gets. It also explains why when it comes to support, the spouses or the parents are compelled to prioritize first the needs of the illegitimate children before you can actually take care of the needs of the illegitimate ones. So for example, A is an illegitimate father of B. Now while A is compelled to actually give support to B, it presupposes that even before he can do so, he has to make sure that he takes care of the needs of the legitimate children first. Bakit? Kasi nga, ayaw natin ng may illegitimate children because the idea is it destroys the family. So very conservative kasi yung batas eh. Again, it points back doon sa pinag-uusapan natin that marriage is vested with public interest. Ano pa? Let us talk about impugning the legitimate status of children. Diba? Under the law, you can only, or the father can only impugn the legitimate status of this child, hindi ba, within a certain period. After which, nagpre-prescribe na siya. So, anong ibig ko sabihin? Let us say si A and B are married. Now, unbeknownst to A, B actually got pregnant and the father is C, not A. So, pinanganak sila si D. So, nung pinanganak ngayon si D, so obviously, he is not the son of A. So, ang tanong dito, ano ang remedy niya? Can he impugn the legitimate status of the child? The answer is yes, kasi hindi naman sa kanya talaga, di ba? Yung tipong pag tinitingnan niya, hindi niya kamukha, hindi ba? Talagang yung demeanor, wala man lang kapareho sa kanya. So obviously, may duda ka na. Baka hindi ko anak ito, hindi ba? Although of course, hindi naman porket hindi mo kamukha yung bata, ibig sabihin hindi ikaw yung ama. Hindi ba? Kasi kadalasan naman sa mag-asawa, ito yung natutunan ko. Halimbawa, may lalaki at babae. Pag nagkaanak sila, kung sino ang kamukha, halimbawa, kamukha yung tatay, o kaya mas kamukha yung nanay, napansin ko, kung sino ang kamukha, ibig sabihin siya nag-enjoy. Lang yun, hindi ba? But let's be honest about it in this case. Assuming A, of course, realizes na hindi niya anak ito. But by that time, 10 taon na yung bata, 12 taon na yung bata. Can he still challenge the legitimate status of the child? The answer is no. Why? Because under Article 170 and 171 of the Family Code, ano bang sinasabi doon? Diba? A father can only impugn the legitimate status of the child within a period of 1 year from the knowledge of his birth or the recording of his birth, hindi ba? Where they reside in the same community or municipality. Kung hindi naman sila magkasama but they reside within the Philippines, the period is 2 years. And of course, if he is abroad, the period is 3 years. After the 1, 2, or 3-year period, as the case may be, di ba, the father can no longer challenge the legitimate status of a child. So for all intents and purposes, that child becomes his. So ang tanong dito, attorney, Hindi ba siya unfair? Hindi ba? Hindi ba lugi ako dahil sa sitwasyon na yan? Ang sabi ng batas, hindi. Why? Because according to the Supreme Court, in a long line of cases, the idea is to protect legitimate children at all times because legitimate children is the very embodiment of the family. Because legitimate children presupposes that their parents are actually married. So ang gusto ng batas, mag-asawa kayo. At kung mag-asawa kayo, maraming mga perks na ibibigay sa inyo, kagaya na nga nito mga legitimate children. So ang nangyayari dito, the law really discourages us to have illegitimate children. There is this interesting case of Jesus versus Juan Diaz. It's relatively an old case na din naman, but it's very, very important because the court makes certain pronouncements. And again, if you look at those pronouncements, they go back doon sa understanding natin that marriage is impressed with public interest. So ano yung kaso na ito? In this case, ang nangyari, yung si A at B, sila allegedly ay legitimate children ni C at D. But it turns out, ang totoong tatay nila hindi si C, kundi si E. So while their birth certificates would suggest that their parents are actually C and D, hindi ba? Meaning they are legitimate children of C and D, he subsequently issued a public instrument acknowledging the fact that both A and D are his illegitimate children. And what makes it this interesting, namatay ngayon tong si E. Si Juan Dizon, namatay siya. So when he died, may mga property siya, may mga ari-arian siya. So syempre, gustong magmana ngayon itong si A at B. Dahil ang sabi nila, illegitimate children kami ni E, and our basis is this public instrument, which is, since public instrument, it was actually notarized. So, ibig sabihin na ina-acknowledge kami na illegitimate children kami. Kaya lang ang problema, while that document recognizes them as illegitimate children, their respective birth certificates would show that they're actually legitimate children of both C and D. So, ang tanong, pwede ba silang maging heirs? And the answer is no, hindi ba? At napakaganda ng mga sinabi ng Korte Suprema. Una, diba, yung unang sinabi ng Korte Suprema dito, di ba there are four pieces of evidence where filiation can actually be established. Yung una, yung recording of birth or final judgment. Yung number two, acknowledgement of filiation either in a public instrument or some handwritten instrument. Number three, open and continuous possession of the status of a legitimate child. And number four, all those other pieces of evidence allowed by the rules of court. Now, ang sabi ng korte, with respect to the first two pieces of evidence, just take note of this, yung recording of birth or final judgment, o yung acknowledgement in a public instrument or in a handwritten instrument. Okay? If these two can actually be presented, they do not require a separate court proceeding, or they do not require the court to actually confirm their a child's status based on any of these two pieces of evidence. So hindi mo na kailangan mag-file in court. If you can present the same, it seals the deal. Therefore, you enjoy your legitimate status either as a legitimate or an illegitimate child. However, with respect to open and continuous possession of the status of a legitimate child, and number two, all the other pieces of evidence allowed by the rules, you need actually court's confirmation on this. You need to go to court so that the court can vet all these pieces of evidence and subsequently declare your status or as an illegitimate child. So malino yung sinabi ng court na yon, hindi ba? Now, let's go back to the case. Ang sabi dito sa kaso, illegitimate children sila. Dahil yung tatay nila mismo ang nagsabi, in-acknowledge sila. But here is where it gets complicated. Dahil sabi ko nga kanina, kahit sabihin na mayroong public acknowledgement na illegitimate children sila, malinaw naman na yung birth certificate nila sinasabi sila ay anak ni C at D at hindi ni E o ng decedent. So ano ang ika nga ay mapaprioritize diyan o anong i-consider diyan? Ang sabi ng batas, ang i-consider diyan is the fact that both A and B are the legitimate children of C and D. Why? Because as I said, since marriage is impressed with public interest and there is a need to protect legitimate children, mas maganda na consider silang legitimate children because number one, if they are legitimate children of C and D, they are mas essential yon to maintaining harmony and establishing the family. And number two, mas marami silang mga privileges na makukuha because, yung mga perks are actually accorded to them. Hindi ba? So in this case, since their legitimate status was never actually impugned, so notwithstanding the public document which ordinarily in itself is sufficient to establish your status as legitimate children without any court's intervention, the fact remains that you are now considered legitimate children of A and D. Diba? Kasi unless you impugn within the prescriptive 1, 2, 3-year period as the case may be, your status as legitimate children would become permanent. Again, it's in keeping with the principle that marriage is impressed with public interest. Kaya yun din ang dahilan kapag ang bata ay illegitimate, the illegitimate father actually does not exercise parental control over him. Wala siyang parental authority. Yung parental authority nasa nanay lang. Yun din yung dahilan kung bakit wala siyang right to custody because yung custody belongs to the mother. Yun din yung dahilan that his right is only limited to visitation right. And in fact, if the mother is proven unfit, the illegitimate father does not automatically become the person that exercises parental authority over the child. Pwedeng ibigay sa lolo, lola, or sa kapatid, whoever is actually capable of raising the child. Why? Because the illegitimate father does not have any parental authority over the child, although he has the obligation to give support. So anong sinasabi natin dyan? Again, ayaw ng batas kasi talaga ng illegitimate children. Kasi mas gusto nila ma-preserve yung pagpapamilya. Kaya very, very crucial for us, I think, habang binabasa niyo itong family code, na maintindihan ninyo yung principle na yon. Kaya it makes sense to memorize Article 1. Kasi di ba, because Article 1 basically tells us that number 1, marriage is a permanent union between a man and a woman. Number 2, it is an inviolable social institution precisely because it seeks to establish conjugal and family life. Number 3, because of that, it is not subject to any stipulation. Everything is provided for by law. And number 4, even if you can fix the property relations, it's still subject to limits imposed by the family code or any appropriate provisions of law. So, yung Article 1 na yan, everything basically emanates from that, hindi ba? Kaya nga merong isang kaso sa 2014 case, is the case of Romulo versus People. In this case, the priest allegedly performed an illegal marriage ceremony because there was actually no marriage license presented. And under the revised penal code, kapag walang marriage license tapos nag-perform ka ng marriage ceremony, you are actually held liable criminally by law. So ang sabi ng priest, di ba, I know that there is no marriage license but I did not actually perform any marriage ceremony. What I practically did there was to actually give my blessing to them because they're pretty much in love with each other. So anong sinabi ng Supreme Court dito? Dalawang bagay lang, hindi ba? Kung walang marriage license, you perform a marriage ceremony, you are held criminally liable. Bakit? Kasi importante sa batas na mabuo ang pamilya, and if you are responsible for something that does not conform to or comply with the legal requisites of law, you can be held liable. Hindi ba? Kasi nakalagay yan sa revised penal code. Pangalawa, with respect to marriage ceremony, you have to understand that the law does not actually impose specific formal marital rights. So any kind of proceeding or ceremony would be sufficient for as long as both parties, meaning the husband and wife, will appear before the solemnizing officer. Number two, that they will actually take each other, husband and wife, in the presence of at least two witnesses. So if those conditions are present, then there is a valid marriage ceremony, which of course is a requisite for a valid marriage. So I hope that's very, very clear. Alam ko kasi, sa totoo lang, mahirap talagang magmahal, ano? At 'pag nag-asawa ka, totoo talagang hindi yan parang kanin na 'pag ayaw mo na kapag mainit na kanin na 'pag napasok ka, iluluwa mo. Kaya nga ako 'pag tinatanong ko ng mga estudyante ko, "Sir, hindi ba ready na ako magmahal? Ready na ba akong mag-asawa?" Naku, hindi pa. Kasi 'pag tinignan mo yung family code, napakahirap ng mga bagay na dapat mong sundin diyan. And besides, mahirap talaga magmahal, dapat mature ka niyan, di ba? Kaya nga ito bago tayo bumalik sa lecture, meron akong mga payo sa inyo 'pag nagmamahal kayo para ika nga kung may karelasyon ka, mas maganda pagsasama ninyo. Una, and take note of this 'pag nagmamahal ka, dapat walang pride sa puso mo. 'Di ba? Kung nag-away kayo ng girlfriend mo, ng boyfriend mo, nag-away kayo ng asawa mo, dapat siguro after a few minutes bati na kayo, hindi ba? Huwag niyong hayaan na matapos ang gabi na hindi kayo nagbabate. Dapat walang pride sa puso niyo Alam mo kung bakit? Ang pride kasi parang brief 'yan. Hangga't hindi mo binababa, walang mangyayari. Hindi ba? Pero sabi sa akin ni Attorney Villasis, "Attorney, hindi totoo 'yan. Ako, kahit hindi ko ibaba, may nagaganap." 'Di ba? Tinatabi niya lang daw, parang brief. Tinatabi niya lang daw. So una 'yan 'pag nagmahal kayo dapat walang pride sa puso ninyo. So pangalawa, hindi ba? So importante ito 'pag nagmamahal kayo, dapat ito alam ko paborito ito ni Attorney Villasis, sinasabi niya din ito Dapat 'pag nagmamahal ka hindi mo binibilang or sinusukat ang pag-ibig. Alam niyo kung bakit? Kasi 'pag sinukat mo, ibig sabihin may hangganan, hindi ba? Pero siyempre hindi totoo 'yan, walang forever ano. Sa buhay, ang forever lang si Lord God at si Senator Enrile. Other than that, walang forever, 'di ba? Oh, si Senator Enrile parang forever nga, no? Parang ayaw mamatay. 98 na. 98 na buhay pa no? Para sa akin si Senator Enrile, ito yung tipo ng taong buhay pa, nagpapara, 'di ba? Nakapunta ako ng Malacanang, I'm not making this up nakita ko siya pumapasok pa sa office, 98 na, pambihira And in fact sabi nila magtatayo daw siya ng negosyo, clothing line. Ibebenta daw sa SM at saka sa Ayala Mall. Alam mo kung ano yung pangalan ng kanyang store? Forever 91. Ayan, kumusta naman, hindi ba? So anyways, balik na tayo sa pinag-uusapan natin. Ayoko lang antukin kayo, hindi ba? So let's go back to what we're discussing about. Now, take note of this If you're taking the bar exam, it may actually do you well to memorize both the essential and formal requisites of a valid marriage. Kasi pag nakalimutan mo yung mga specific grounds provided for in Article 35, Article 36, 37, and 38, and those provided for in Article 45 with respect to voidable marriages, kahit makalimutan mo yon, hindi ba? Pagkabisado mo yung essential and formal requisites, masasagot mo pa rin if the marriage is void or voidable. Why? Because, di ba, the law is very clear. If there is an absence of either the essential or formal requisites, then the marriage is ipso facto void, as in ab initio. Number two, if there is defect in any of the essential or formal requisites, then the marriage is voidable. And number three, if there is a mere irregularity in the formal requisites, they do not affect the validity of the marriage, but of course, the erring person responsible for such irregularity may be held liable criminally, administratively, or even civilly as the case may be. So let us talk about the essential and formal requisites of marriage. Number one, the first essential requisite is legal capacity. Hindi ba? Between the contracting legal capacity of the contracting parties, who should be a man and a woman. So, ibig sabihin, kung same-sex marriage yan, there is no legal capacity because the essential requisite is expressly telling us that it should be between a man and a woman. Now, when is there legal capacity pa? There is legal capacity is if at least you are 18 years of age. So, paano kung nakalagay doon sa kanyang birth certificate, 18 na siya, but in reality, 17 siya, is the marriage valid? No, the answer is it's void because your actual age is the condition sine qua non for you to be considered as possessing legal capacity. There is also legal capacity if you do not suffer from any impediment provided for under Article 36, which is psychological incapacity. Number 2, Article 37, yung incestuous relationship. And number 3, Article 38, or marriages that are considered void by reason of public policy. So for example, a step-parent and a stepchild would want to actually get married, or the adopter or the adopted will actually get married, then wala silang legal capacity. So if that would be the case, the marriage is void. So nakita nyo, hindi mo kabisado yung grounds. Pero dahil kabisado mo yung essential and formal requisites, you can actually survive. Number 2, consent should actually be freely given between the contracting parties. So ibig sabihin ng freely given, hindi ka pinilit. Kapag pinilit ka, either because there is fraud or deceit, or for example, there is threat or intimidation, so it amounts to a vitiated consent. So may defect yung issue ng consent, which will actually make the marriage voidable. Now, let us discuss now the 3 formal requisites. So the first requisite is the authority of the solemnizing officer. Now, take note of this, whether any problem with respect to said authority is considered a defect or an irregularity is actually dependent upon certain circumstances. Like for example, hindi ba, it is provided that one of the authority of a rabbi or a priest is that either or both contracting parties should actually be members of the sect or church to which he belongs. So if either or both of them are not actually members of his church, then the understanding is he lacks authority. So in which case the marriage is considered void. Hindi ba? However, kung ang issue lang yung jurisdiction. Kasi di ba if you look at those people authorized to solemnize marriage, so yung mga padi nga, yung mga pastor, yung mga mayor, yung mga judges, justices, hindi ba? Of course, meron yung in articulo mortis, but we're not really concerned so much with that. Diba? Because for as long as the marriage is in articulo mortis, a ship captain, for example, can solemnize marriage. Pero yung problema, yung pare, yung mayor halimbawa, yung judge or justice, may territorial jurisdiction sila. So let us say kung ikaw ay RTC judge sa Manila, doon ka lang sa Manila magkakasal. Hindi ka pwedeng magpakasal sa Quezon City. On the other hand, if you are mayor of a pari, of any town in Cagayan, you cannot actually solemnize marriage in Manila, hindi ba? And the same thing can actually be said about the priest. Kasi yung priest dun lang sa diocese niya as he was actually placed by the bishop of the Catholic Church. So ang tanong, what if they go outside that? So interestingly, sabi ng Supreme Court, it's just a mere irregularity. Hindi ba? So which of course does not affect the marriage. Pero importante, yung authority of the solemnizing officer. Now, interestingly, even if the solemnizing officer has no authority, if either or both parties believe in good faith that he is so lawfully authorized, the understanding is he still has that same authority. Now, ito lang yung dapat yung tatandaan dyan. Yung tinatawag nating mistake of fact or mistake of law. Kasi meron dyan, I remember when they were deliberating on the family code, nagtalo dyan si Arturo Tolentino at saka si Justice Caguiwa, hindi ba? And the general weight of opinion is that there should be mistake of law, not mistake of fact. Kasi di ba, if it's a mistake of fact, then good faith does not actually, if there is mistake of law, good faith should not actually operate. So anong example ng mistake of law? So for example, may janitor, you believe in good faith that that janitor is lawfully authorized to solemnize marriage. So even if there is good faith, it cannot actually be considered as one that would equip that solemnizing officer as lawfully authorized to solemnize marriage. Why? Because it is clearly a mistake of law. Because a janitor is not amongst those enumerated under the law to actually solemnize marriage. O, pero kung halimbawa, um, pastor, hindi ba? Pero katoliko ka, but you believe in good faith that even if he is a pastor and is not necessarily connected to the church to which you belong, you believe in good faith na authorized pa din siya, then that is considered a mistake of fact. Pero ganito yan ha, if you're answering the bar question, it would make sense to just basically argue both. Like you can say that there are actually two schools of thought kasi mas maganda yon pag nakita ng examiner yon, mas okay yung grade mo, hindi ba? Importante din of course is a valid marriage license. So kapag wala ka diyang parental authority, walang parental advice, normally a marriage license is good for a period of 120 days. So kapag ika nga ay nagka-problema ka diyan, walang parental authority, walang parental advice, nare-reduce na lang yan sa nasususpend siya for 3 months, nagiging valid na lang for 30 days. So you should be able to actually get married within that 30-day period. Otherwise, if you get married after the lapse of that 30-day period or the 120-day period, assuming it's a regularly issued marriage license, then the marriage is considered void. So, ganon ka-importante yung marriage license as a requirement. Now, merong tanong dito, hindi ba? Hindi mo kailangan mag-present ng marriage license if you freely cohabit with each other as husband and wife for a period of 5 years without any legal impediment to do so. Now, naalala ko, nung araw, sabi ng teacher ko sa Ateneo, yung 5-year cohabitation period, yung walang legal impediment, is reckoned on the 5th year. So, ibig sabihin, it's highly possible on the first 3 years, si A may sabit, nagpa-anal siya, but by the 5th year, wala nang legal impediment, then it presupposes they're not required to secure a marriage license. Hindi ganun yan ha. Ang sabi ng batas, there should not be any legal impediment for them to get married with each other for that 5-year period. So, yun lang yung dapat tatandaan nyo dyan. And lastly, a valid marriage ceremony, kagaya nga sinasabi ko, walang specific formal right for as long as they basically accept each other as husband and wife in front of the solemnizing officer before or in the presence of 2 witnesses, then there is already a valid marriage ceremony. Paano kung walang witnesses? According to the Supreme Court, it's just an irregularity which of course does not really affect the validity of the marriage. So masasabi ko lang class, dapat wag niyong kalilimutan yaan. Yung both essential and formal requisites kasi diyan talaga ika nga ay diyan nyo masasagot yung mga tanong kahit nakalimutan mo na yung nakalagay sa Article 35 or sa Article 36, 37, 38 or even sa Article 45. So, anyway, gusto ko lang i-discuss yung kaso ng Republic versus Manalo. No? It's actually a 2018 case. Because in the case of Republic versus Manalo, ang sabi ng Supreme Court, divorce may be validly obtained abroad either by the alien spouse or the Filipino spouse, because there used to be a time under the family code that the divorce should actually be procured by the alien spouse, and the alien spouse could either be a former Filipino or an actual foreigner, hindi ba, in order for that divorce to be valid. So if it's the Filipino spouse who would procure the same, it cannot actually be recognized here. So ang kagandahan dito sa Republic versus Manalo, again, it's a 2018 case. So kahit yung Filipino spouse na ika nga ang nag-procure ng divorce, it can be recognized in our jurisdiction. So ang tanong, sir, hindi ba yung kaso ng judicial legislation? The answer is yes. But this is actually by reason of equity. Because if you look at the decision of the explanation, if you look at the explanation of the Supreme Court in the case of Republic versus Manalo, ang sinasabi ng Supreme Court, if we will deprive the Filipino spouse of the opportunity to procure divorce, she or he will actually forever be dependent upon the alien spouse to do it. So kung gusto siyang pahirapan ng alien spouse, then he cannot do anything about the marriage. And besides, it's kind of unfair, that if the alien spouse could procure divorce, he can actually get married subsequently, while if it's the Filipino spouse, hindi ba? he is prohibited or precluded from entering into another marriage. Kaya in order to basically serve the interest of justice, sabi ng Supreme Court in the case of Republic versus Manalo, so kahit Filipino spouse ang nag-procure ng divorce, the same can be recognized in our jurisdiction. However, take note lang, the marriage should be between an alien and a Filipino. Pag sinabi nating alien ay either an outright foreigner or a former Filipino. Take note of that, hindi ba? So, if for example both Filipinos get married in Japan and they subsequently go to Japan to procure divorce, that divorce cannot actually be considered here precisely because they're both Filipinos. So, gusto ko lang linawin nyo kasi kung magkamisa nakakalimutan natin. Now, huwag niyong kalilimutan yung distinction ng void marriages at saka avoidable marriages. Because if you talk about void marriages, the understanding is that it's as if there is no marriage at all. Hindi ba? Now, a void marriage can always be attacked collaterally. Ano ibig sabihin natin it can be attacked collaterally even if it's not actually the main issue in a proceeding, it can actually be raised as an issue. So, halimbawa, succession. Si A at si B ay mag-asawa dati. Hindi ba? But subsequently, they separated. In fact, without actually filing any petition for nullity or annulment, A decided now to live with C. And subsequently, he died. So now, for all intents and purposes, B would be acknowledged as the wife, hindi ba? Kasi nga hindi naman sila nagpa-annul or pag-nullify. Pero can you actually attack the fact that the marriage between A and B is actually void, so that at the end of the day, B will be disqualified from inheriting from A? Diba? The answer is yes, you can do that, hindi ba? So kaya kahit hindi ka nag-file ng petition for nullity, diba? In any other issue, you can subsequently raise that. Now, why can you actually raise that? Diba kagaya na sinabi ko, diba manahan? O sasabihin ngayon ng mga anak nung kabit, hindi dapat makuha yan ng legal wife. Kasi yung kasal naman nila ay void. And we can actually present pieces of evidence to prove that the same is void. In fact, based on the birth certificates alone, when the woman got married with our dad, she was actually only 16 years old. Hindi ba? And at that time, they are governed by the family code of the Philippines. So therefore, the marriage is void. Can you do that? Can you do that collaterally in a case which involves succession? The answer is yes. You can always attack a void marriage collaterally. But you cannot attack a voidable marriage collaterally. Why? Because if you look at the nature of a voidable marriage, it is valid until annulled. Again, it is valid until annulled. So which means, if you do not pursue a petition for annulment, then it remains valid. And in fact, it's even subject to a prescriptive period. And more importantly, it can even be ratified by cohabitation. So, ibig ko sabihin, that explains why you cannot attack it collaterally. Because if you do not go to court and declare that that marriage is voidable, hindi ba? If you do not go to court, then it remains valid because only the court has the right to tell us in a proceeding that that marriage is actually voidable. Di ba? Kasi if they don't go to court nga, nararatify yan to begin with. So, which is why it cannot be attacked collaterally. Ngayon, why can we attack a void marriage collaterally? We can do that because the presumption is that it's as if there is no marriage at all. Diba? However, sabi din sa Family Code, sa Article 40, but for purposes of the marriage, you need to obtain a judicial declaration of nullity. So again, if the idea is to remarry, you have to go to court and pursue a nullity case so that the court can say the marriage is void, and with that declaration, you can validly enter into another marriage because otherwise it becomes bigamous. Diba? So, klaro yun, hindi ba? So, anong ibig ko sabihin dito? Were it not for Article 40, a void marriage can always be attacked collaterally. Because the understanding, again, is as if there is no marriage at all. Only for purpose of the marriage, do you actually need to go to court and file a separate proceeding so that you can obtain a judicial declaration of nullity. Ayan, napasensya na kayo dun sa lecture na ito kasi ginagawa ko dito, nagkakantuhan lang tayo, naguhuntahan lang tayo kasi alam ko naman, hindi ba, pag-aaralan niyo uli yung family code. Pero yung ginagawa ko dito, pinapaintindi ko lang sa inyo itong mga bagay na ito para mas ika nga mas madaling sakyan at maintindihan yung mga provisions kapag ika nga pinag-aralan nyo na, hindi ba? So nakakatuwa dito sa sa Villasis Law Center. Namimiss ko na lang din yung face-to-face kasi naalala ko ng face-to-face dito, natutuwa ako, ang daming nag-aaral. Tsaka alam mo, sa karanasan ko sa Villasis Center, ting nagtuturo ako dyan ng face-to-face, talagang ang daming magaganda. Yun nga lang, ang dami rin pangit. Di ba? Ang hirap maging pangit, pag pangit ka, walang may gusto sa'yo. Napansin mo yan. Sa court nga alam niyo ba sa courtroom, kapag ka maganda ka, ang bait ng judge sa'yo. Parang, Nicole sagutin mo lang yung tanong, I know you can do it. Pero pag pangit ka, wala pang arraignment, guilty ka na. Di ba? Kahit sa Facebook, pag maganda ka, ang dami mong follower. Pero pag pangit ka, ikaw ang follower. Napansin mo yun, pag maganda ka, nagsuot ka ng bikini, kinabukasan, viral na yan sa Instagram. Pero pag pangit ka, nire-report ka sa Facebook. Pinapatanggal nila sa Instagram. Kawawa ka naman. Hindi ba napansin nyo yan, Tsaka napansin mo, pagka tinukso ka sa maganda, kinikilig ka. Di ba? Pagka tinukso ka kay George. Guys, huwag niyo akong tuksin kay George, nakakaya. Baka isipin niya, feeling ako. Di ba? Pero pag sa pangit ka tinukso, tarantado kayo Tol, wag naman ganun. Sira ulo kayo Tinutukso niyo ako Gago kayo. Susukan na lang kung gusto niyo Diba? Anyway, break lang yan. Nabanggit ko lang naman. Now, ito yung mga bagay na gusto ko lang sabihin sa inyo kasi makakaligtaan nyo na ito Di ba yung voidable marriages, they can actually be ratified by cohabitation. Pero may exception din Yung exception dyan, yung Article 45, Article 45, fifth paragraph. Ano yung Article 45, fifth paragraph? Yung physical incapability to consummate the marriage. So halimbawa, A got married with B, who happens to be impotent. But despite that, she decided to live with B, together as husband and wife. Now, after 12 years, he wanted now to file a petition for annulment. Okay, is the cause of action already prescribed? According to the Supreme Court, the cause of action has not yet prescribed because it is not something that can be ratified by cohabitation. Hindi yan kagaya halimbawa ng marriage during a period of insanity. When the insanity is gone, diba, both parties can choose to live together as husband and wife, and that actually cures the defect. Or for example, 18 years old sila, but by the time they get to reach the age of 21, they both decide to cohabit as husband and wife, then you can no longer go to court and file a petition for nullity, hindi ba? So yun yung mga dapat natatandaan nyo at huwag nyong kalilimutan. Now, let us talk about the obligations between husband and wife. Diba? Because husband and wife, diba, they are obligated to live together, diba, under one roof. They're also obligated to render mutual love, respect, and fidelity. And they're also legally obligated to give support to each other. But take note of this, with the exception, take note, with the exception of the obligation to give support, the other rights and duties legally demandable. So halimbawa, your wife is obligated to love you. Your wife is obligated to be loyal to you, to observe fidelity. If she does not do that, you cannot go to court and compel her to love you. Hindi ba? Di ba in one case ang nangyari, umalis sa conjugal dwelling yung lalaki. The woman now filed a case in court, asking the court to compel him to return back to the conjugal dwelling. Anong sinabi ng Supreme Court? It cannot be done. The most that the court can do is actually encourage, admonish, or even suggest that that person should go back to the conjugal dwelling because amongst his rights and obligations would be to make sure that he lives together with his wife. Hindi ba? But ngayon ang tanong ay bakit? Because all these other obligation, because all these obligations, again, with the exception of the obligation to give support, they are not legally demandable, although the absence of this can be used as basis to avail of other remedies. Like, for example, you can file a petition for nullity based on psychological incapacity because of his incapability to love you, because of his incapability to be to remain faithful, because of his incapability to be loyal to you, or to at least live with you under one roof. But those obligations in themselves cannot actually be compelled upon them. Hindi ba? Kagaya nung sa kaso na yun, hindi ba? Umalis yung lalaki, ayaw nang bumalik sa bahay, the court cannot compel him to go back. Bakit? Because that obligation, according to the Supreme Court number 1, is a purely personal obligation, and that is an obligation to do. So if you compel him, it violates his right his right to liberty, because he should be able to exercise discretion as whether or not he wants to love you, or whether or not he wants to live with you. So ano yung lesson natin dito? Pagdating sa rights and duties between husbands and wives, sa bandang huli, isang bagay lang ang sinasabi niyan: kahit kailan, hindi pwede pilitin ang damdamin. So kung hindi ka na mahal ng asawa mo, wala kang magagawa. Kung ayaw nang tumira ng asawa mo sa bahay mo, wala ka na ring magagawa. But of course, if he refuses to give support, you can always go to court, either to file a petition for support civilly, or actually file a case for VLC, assuming that the denial or refusal to give support would amount to an economic abuse. Yung tipong kawawang-kawawa ka na, di ba? But other than that issue on support, kung yung pagmamahal ayaw nang ibigay sa'yo, hindi mo siya pwedeng pilitin because it's not legally demandable. So yan ang lesson dyan. Hindi pinipilit ang pagmamahal. And that also explains why there is no breach of promise to marry. Kasi kahit pinangakuan kang pakakasalan, kung nagbago ang isip niya, hindi siya pwedeng pilitin. Kaya kayo, huwag niyong pipilitin yung tao na mahalin kayo, because it is something that only that person can answer for himself. Kung gusto kanyang mahalin, of course, sariling volition niya yan. So, ito yung mga bagay na sa tingin ko ay dapat tatandaan natin, hindi ba? Kasi at the end of the day, if you talk about the family code, it's really all about understanding what the nature of marriage is. Again, siguro in sum, gusto ko lang banggitin, wag niyong kalilimutan that marriage is impressed with public interest. And the reason why it's impressed with public interest is because Article 1 of the Family Code says so. Kaya ang daming repercussion family code, umiikot lang doon sa fact that the marriage is impressed with the public interest, and such being the case, ang interest ng Estado is to always preserve marriage, is to always guarantee that the rights of the legitimate children are taken care of, and that the family is actually secured. Hindi ba? Kaya nga kung may legitimate child ka, kagaya ng sinabi ko, kailangan bigyan mo muna yung legitimate children. So kung kulang yung sweldo mo para sa legitimate children, the illegitimate child cannot go to court and compel you to give support. Hindi nga pwede yung nanay niya magsampa ng kaso ng bawsi sa'yo. Kasi kailangan unahin mo muna yung legitimate children mo. Kung may sobra, pwede mong ibigay sa kanya. Kung halimbawa, conjugal gain kayo, yung separate property mo kulang, pwede mong kunan dun sa conjugal. Hindi ba? Kaya lang, advance ng share mo na yon, nagkakaroon ka ng utang. So kung mapapansin mo, gano'n lang talaga umiikot yung batas. So I hope kahit paano naintindihan yung family code, but sa pag-aaral niyo, I hope you be guided by this explanation. Ngayon, kung hindi nyo naintindihan, okay lang, kasi libre lang naman. Diba? Lagi akong kinukuha kaya ni Atty. Villases pag libre. Diba? Pero madalas naman niya rin akong nililibre, so it's okay. So with that, thank you so much, class. I hope may natutunan kayo. At wag na wag kayong magsasawa na mag-enroll dito sa Villases Law Center. At yung mga kaibigan nyo, i-encourage nyo rin. Kasi kagaya na sinabi ko, Villases Law Center is like New York. If you can make it here, you'll make it anywhere. Maraming salamat. Thank you.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung object mo. No? So if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So gano'n lang kasimple. So okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So okay na tayo dyan. So dito tayo sa exception. So there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can.
Walang natira, medium period. Pag may natirang mitigating circumstance, minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are deemed controverted already. So maski walang reply, all matters raised in the answer are deemed controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay? He may not want the carabao. Okay? But in application of payments, is the consent of the creditor required? Definitely. There is no question because he would accept. Okay. Then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang ang epekto, maximum period. Offset rule, i-offset mo muna, tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So dito tayo sa exception. So there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply, under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira video video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are deemed controverted already. So maski walang reply, all matters raised in the answer are deemed controverted already. If you talk...
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can. Together we can.
Walang natira video video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, section.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are been controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together, we can. Together, we can.
Walang natira medium period. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natira, medium period. Pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are being controverted already. So maski walang reply, all matters raised in the answer are being controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay? He may not want the carabao. Okay? But in application of payments, is the consent of the creditor required? Definitely. There is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can. Together we can.
Walang natira video. Pag may natirang mitigating circumstance minimum. So, ganun lang kadali yung offset rule. No? So, if there is a combination of aggravating and mitigating circumstance, i-offset mo muna. Pag may natirang aggravating, maximum period. Pag wala natirang medium period, pag may natirang mitigating circumstance, minimum period. So, ganun lang kasimple. So, okay na tayo sa general rule, ha? No? Sa general rule, dalawa yung consider natin. Multiple aggravating circumstance, isa lang epekto, maximum period. Offset rule, i-offset mo muna. Tingnan mo kung ano yung remaining modifying circumstance. So, okay na tayo dyan. So, dito tayo sa exception. So, there are 4 exceptions. No? Number 1, exception.
So, of course, my friends, you have, of course, a reply. To make it simple, a reply is an answer to an answer. Ayan. And the purpose of the reply is to transverse new matters raised in the answer. Transverse, dispute, di ba? Contest, transverse, new matters raised in the answer. But even though you fail to file a reply under the new rules, no? If you fail to file a reply, okay lang. Kasi exceptional situation lang. Ang rule na ngayon, all new matters alleged in the answer are deemed controverted already. So maski walang reply, all matters raised in the answer are deemed controverted already. If you talk
In relation to dation in payment, the answer is yes, because the debtor would offer another thing. Example, if the thing to be delivered is a sum of money like 20,000, the debtor instead would offer his carabao in payment of his debt, and therefore the consent of the creditors is absolutely necessary. Okay, he may not want the carabao. Okay. But in application of payments, is the consent of the creditor required? Definitely, there is no question because he would accept. Okay, then there is consent. However, okay, the question that would have to be answered is to which debt the payment should be applied. The third
Together we can. 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 Together we can.